Do you really need a lawyer for your domestic violence case? In this video, I'm going to be going over 5 situations where you may have been arrested for domestic violence and wondering if it's really necessary. And I am a lawyer, so you may be thinking, of course she's going to say you need a lawyer. But actually, spoiler alert, there are 3 situations I'll be describing where you do need a lawyer and 2 when you don't, which are not necessarily obvious. My name is Veronica. I'm an attorney here in California. I help people put their cases behind them so that they can enjoy their lives and their futures. I'm also the creator of a course called Defeat the DVRO, in which I teach you how to represent yourself at a domestic violence restraining order hearing and win. So if that is something you are interested in, you need help with, you can get your free first class via the link down below. Okay, so let's jump right in. We're going to be going through 5 situations in which you may be wondering, do I really need a lawyer? Number 1, the cops told you that you don't need a lawyer. This is something that I hear not just from clients or potential clients, but I also hear this on body-worn video when the cops are arresting someone. Now, I only get body-worn video when somebody really did need a lawyer because charges were filed against them in court. It happens all the time. As you are getting arrested, the cops will say, you know what, it's probably just going to get dropped. The DA is not going to do anything with this case. You know, don't worry, man. It's just, we got to take you in, man. Sorry about that, but we just got to do it. We're just doing our jobs. What they're trying to do is keep the situation calm and have a good night, because people may attack them, fight them, get a gun, get a knife. You know, they don't know. They want to just do their jobs and go home to their families, right? But look, if the cops really didn't want charges to be filed against you, they could have potentially arrested the other party too. Typically they don't, but if they come out to a domestic violence situation and it is he said, she said, there is really no evidence either way, or they genuinely do believe you and want to help you, they could just arrest the other party. They could just arrest the other party if they want to, or they could arrest you both. They don't have to just arrest you. If you were the only one arrested or you were arrested, then I don't think you can rely on the advice from the police that you don't have to worry about this and that you don't have to hire a lawyer. Now, sometimes you will get a call from a detective after you bond out of jail, and the detective might call you and say, you know what, this whole thing's probably going to be dropped. I just want to hear your side of the story. Okay, so first, stop talking to detectives. In fact, do not answer any calls from unknown numbers after you get out of jail before your first court date. They're allowed to lie to you. And this is something that maybe you didn't hear during your arrest, but police will often say during an arrest, oh, we just want to get your side of the story. They want to get incriminating statements. And then once it makes it to court, the DA is going to tell me as a defense attorney, hey, look, your client admitted this. Your client admitted that he pushed her. Maybe you just described a self-defense situation. Maybe they cut you off before you could tell the whole story. But that is just going to be used against you. And look, if the detective is calling you, they are obviously investigating the case. The case has actually made it to the point where there is a detective assigned to it. So unless you get documentation that the case has been rejected, don't trust the detective. Don't take legal advice from police. So if the police tell you you don't need a lawyer, that does not mean that you don't need a lawyer. You should still get one unless you have documentation that the case has actually been rejected. Number 2, if you were released per Penal Code Section 849, detention only. So basically, you didn't pay bond, you didn't get a future court date, you were just released. And in some counties, if you go to the sheriff's website that has all the jail records, it will actually say released per PC or Penal Code 849. What this means is that your arrest officially is considered a detention, not an arrest, and that basically the case is over. There's nothing else to be done, unless they get more evidence, or maybe you are arrested for something similar and they decide to charge both. So in this situation, no, you don't need an attorney. The case is over. You can put that behind you, thank your lucky stars, and hopefully take steps to make sure that it never happens again. Number 3, a lawyer told you to wait to see if charges are filed at the first court date. Okay, so I've had people call me for consultations many times who tell me that they talked to other lawyers, but the advice just didn't really sit right or sound right to them, and so they were calling me. They were arrested, they have a court date coming up, but they have not been to court yet. So the lawyer tells them that they should wait, they should go alone to the first court date, and they should call the lawyer if charges are filed, but do nothing until then. Before your first court date, the police send their police report to the prosecution, right? And then lawyers at the prosecutor's office review the file, and they have to decide whether or not to file charges against you, and if so, if they should be more serious charges, less serious charges to go along with whatever the police arrested you for, or to drop the whole thing altogether. Now, defense attorneys for domestic violence cases, especially if it was your first time, absolutely can intervene on your behalf and advocate for the case to be dropped. We can talk to the prosecutors assigned to your case, explain your side of the story, the good things about you, character letters, and we can advocate for the case to be dropped. Unless you call me and charges have already been filed, I'm going to try to intervene and get your case dropped. Now, when I handled murder cases, attempted murder, gang cases, those cases, they're all going to be filed pretty much and filed very quickly. So this process of trying to contact the DA before court for, a gang drive-by shooting, it makes no sense. You don't do it. But for domestic violence cases, it is different. You have seen firsthand, if you are in this position, how easily the police arrest people for domestic violence, right? Without there being a ton of evidence. And if you are not the sort of person that the state generally, like a gang member, wants to put away, then they are going to give you the benefit of the doubt. So we have them being overburdened by too many domestic violence arrests. And then we have you, someone that potentially, if you have no other criminal history, does have the benefit of the doubt. So why would a lawyer say this to you? Okay, there are a few reasons. First, maybe you are not in California, and I don't know what the process is if you are not in California. I'm only licensed in California. So that's one reason. The lawyer also, maybe they don't know this because they don't focus their practice on domestic violence. Maybe they are doing just murders, attempted murders, all this gang stuff, and they treat all the cases the same way. And part of the reason why I focus my criminal defense practice on one thing, on domestic violence, is because different types of crimes are treated differently. And it's important to get really, really good at defending that type of crime. You can imagine financial fraud, kidnapping, murder, bus hijacking, all kinds of crazy stuff that happens. They are all very different. And domestic violence cases are different too. But I want to get as good as I possibly can at one thing, have a great procedure in place to get great results. And so that is why I focus on DVs. So maybe their practice is just not narrow and they just don't have a procedure in place to contact the DA before the first court date for domestic violence cases. The third reason is maybe the lawyer doesn't want you as a client for some reason. Maybe it's nothing personal unless you were rude to them, but maybe they are too busy and they just don't want the case at this time. So as long as your domestic violence case is in California, even if a lawyer told you during a consultation, oh, just wait until the first court date, just see what happens, you still need a lawyer. I don't agree with that advice. You definitely need a lawyer. Number 4, the victim wants to drop charges. Okay, if you're here and you are doing your research, you probably already know this, so I will keep it fairly quick. But if you're new to this, once you've been arrested for domestic violence, the case is out of the victim's hands. It does not matter what the victim wants. The prosecution will do whatever they want with the case. The DA assumes, even if the victim contacts them and says, I want this dropped, I lied, it doesn't matter. The DA assumes that the victim is under duress or just does not know what is best for them. So even if the alleged victim is on your side, you still need a lawyer. Number 5, the case has already been declined by the DA. Okay, so I've had people calling me wanting to hire me, but they already went to their first court date and they were told that no charges were filed and it was a DA reject. If that happens, you don't need a lawyer unless the case was referred to the city attorney. In certain very busy counties, Los Angeles is one of them, some areas have a city attorney. So the city of Los Angeles, the DA's office belongs to Los Angeles County, and then there's also the city of Los Angeles, so that has its own prosecutor's office. And there are various other areas within Los Angeles that have their own prosecutor's office. So if that happened, if your case was referred to the city attorney, you do still need a lawyer because the city attorney is another type of prosecutor. Now, the good news is if your case was originally a felony, it's now at worst a misdemeanor because the city attorney only prosecutes misdemeanors. So when this happens for my cases, what I do then is I contact the city attorney's office immediately, let them know that my client is represented, give them everything I gave the DA with my client's side of the story, good things about them, character letters, etc. Give them all of that. And at that point, they can drop the case, they can file charges, or they have a city attorney hearing where they decide whether or not to file charges. So in that situation, you do need a lawyer. That is a lot to navigate without knowing exactly what to do, and you could easily screw it up. So you do need an attorney in that case. I hope you found this video helpful. If you do have a criminal case you need help with, feel free to give me a call. You can find my number down below. You can also book a consultation there. If you have a restraining order, make sure you get your free first class in the course. And if you did find this video helpful, please don't forget to like, subscribe, ring the bell, and follow me on Instagram, TikTok, and Facebook.